how? Yes, it is Wednesday afternoon, and now you have to listen to the U.S. lawyers. None of us have been replaced by machines yet. I am relatively new to the firm. I'm still in that process of going around to the different Perkins Coie offices and meeting my fellow partners, two of which will speak after me. And I have yet to meet one that is a computer, that just is artificial intelligence. So I am John Jacobs. This is a little bit about my background. I spent 27 years at the United States Department of Justice's Antitrust Division. I was doing both civil enforcement work and criminal enforcement work, both of which are relevant to the topic I'm talking about today. On the civil side, I did quite a bit of merger control cases, and I very much appreciate the work of FRONTEO and other companies that allow us as lawyers to sift through the mountains of documents that we receive from parties. I'm old enough to have worked on merger cases early in my career where all we received were boxes of paper documents, and we had to go through all of them, and it was very tedious. In addition to merger control cases, I also worked on abuse of dominance cases. On the criminal side, which involves per se unlawful agreements to fix prices, allocate customers or markets. I worked on the grand jury investigations, for example, involving air cargo, the conspiracy involving TFT, LCD panels, as well as more recently, the last one I was in charge of involved the shipping of roll-on, roll-off cargo, cars and trucks that are put on these gigantic ships and shipped across the seas to and from the United States, to and from other countries. So today I will be talking about algorithms and the antitrust risks of using algorithms. I'll talk a little bit about the two U.S. antitrust laws that are most relevant to this discussion, give you an overview of the kinds of algorithms that are used, 5 different situations, from easier to harder and more interesting, and then finish with some unanswered questions as well as some do's and don'ts for you. So there are 2 statutes that are most relevant to the use of algorithms, and the first is Section 1 of the Sherman Act, which requires an agreement among 2 or more people or 2 or more companies. This is most often enforced by my former employer, the United States Department of Justice. And it is enforced both as a civil violation and as a criminal violation. And whether an agreement is only a civil violation, which involves just, if it is proven, a court issues an injunction ordering the company not to do the same conduct in the future. There are no fines involved in the United States. Or a criminal violation, which is much more serious. Criminal fines are imposed, executives may go to jail. Whether it's civil or criminal depends primarily on what you agree on. If it is a per se violation, you agree on price or dividing markets, that is a criminal violation. And I believe that here in Taiwan you have a very similar set of per se violations as we do in the United States, price fixing, market allocation. If all you agree on is to exchange certain information, or if the agreement is not between horizontal competitors but more of a vertical agreement between a customer and a supplier, that is almost always treated as a civil violation. The other statute is enforced by the Federal Trade Commission, which is a second organization in the United States that has both consumer protection authority as well as competition law authority. in Section 5 is worded in such a way that it's quite vague. It prohibits unfair methods of competition, but it largely tracks Section 1 as well as Section 2, which is the United States abuse of dominance statute. And most notable for our discussion here today, it does not require an agreement between two or more entities. So what is an algorithm? An algorithm is simply a set of rules for solving a certain problem. And algorithms are increasingly common. They affect who we friend on Facebook. Every time I make a new friend on Facebook, it suggests, well, maybe you'd like to befriend, some of these other friends of theirs. It affects what we shop for. Whenever I buy something on Amazon, it'll show me several other things that I might be interested in. It even affects, if you're in the dating market, who you date and might eventually marry, because these dating apps use algorithms. And human beings are not the only ones that use algorithms. I read this very interesting article about ants and how they make ant bridges. Ants obviously have very small brains. They don't seem to have a leader, and yet they, in very organized fashion, make these bridges, scientists believe, by following two rules. The first one is, if you come up to a gap, slow down. And the second one is, if you feel another ant on your back, stop. And I think some ants get lost in the process. But here I think you see an ant bridge being built from both directions. And by following, again, an algorithm, they're able to build these remarkable ant bridges. But what we're interested in, of course, is what businesses use algorithms for. As Johnny said, they're increasingly being used for all sorts of things. Planning production, an optimal production schedule. Optimizing your inventory is very important. And most relevant to our discussion, businesses are increasingly using algorithms to set prices. Especially in markets with fast changing prices, dynamic markets. A good example is involving the Amazon marketplace, where buyers who are competing against each other to be the primary company that Amazon will recommend for you to buy their product, to win that buy box. Companies will use algorithms to try to optimize their position and to win that competition. So these are the 5 different situations that I'll talk about. As I said, starting from some fairly straightforward ones, and I'll give you some case examples from them, to some more difficult situations. So let's talk about the first one, where competitors agree to fix prices and they use algorithms to implement their price-fixing agreement. This is an easy one. This is per se unlawful. The lines here between the two competitors indicate that the competitors have agreed with each other in some way to fix prices or allocate markets, and then they use the algorithm to implement it, instead of implementing it themselves as human beings. There was an example of this 3 years ago. The Department of Justice prosecuted what was billed as their first e-commerce case. There was a gentleman whose last name was Tompkins. He worked for a poster company, and this company was selling posters on the Amazon marketplace. He agreed with his competitor to stabilize price competition between them, and then he used computer code to write an algorithm to implement their price-fixing agreement. And he agreed to plead guilty and agreed to spend 6 to 12 months in jail. And you'll see the quote from the Department of Justice there, that government will not tolerate any competitive activity, even involving this kind of situation with an algorithm. The lesson is pretty clear. It's illegal to fix prices, and it's just as illegal to agree with your competitor to fix prices and use a computer to implement that agreement. So situation number 2. What if 2 or more competitors agree to use the same algorithm to set prices? Again, a per se unlawful agreement. The competitors have agreed with each other. Let's use this same algorithm. It's illegal to agree on specific prices. It's illegal to have competitors agree, let's agree that my prices will be 5% below yours. It's illegal to agree to a particular pricing formula. It's also illegal, even if you don't know what the prices will be, to let an algorithm figure that out for you. Let's say there's a new algorithm on the market that optimizes our joint profitability. And we agree to use that algorithm, not knowing what prices will be assigned to us, but we trust the algorithm to reach the profit maximizing price. That is illegal. A third situation is a little bit more complicated. Let's say that there is an algorithm company that initiates an agreement among the competitors in the industry. Let's say the algorithm company comes to each of the competitors and says, we're the best algorithm on the market, and we think you all ought to use us. And it involves, let's say, everyone increasing their price more than they would otherwise. A natural response might be, as a competitor, I don't really want to raise my price unless I know my competitors are also raising the price. And the third party, the algorithm company, says, don't worry, I'm talking to them and they're agreeing to use the same algorithm. You're all going to go up together. Who thinks that is per se unlawful? Who thinks that's a violation of U.S. antitrust law? Well, is there an agreement? There's no, I'm sorry, I just, how do I get back? Not that way. How do I reverse that? Okay, sorry. I went to hit the red line. There is no agreement between the competitors. There's no communication between the competitors. I guess the question is there an agreement? As I say here, both the third party and the competitors could be liable, depending on what the evidence shows about whether there is, in essence, an agreement among the competitors that's being orchestrated by the third party. Now, how does that work exactly? I'll give you a couple of case examples that came up in the United States. The first one was in 1998, and this was a case brought by the Federal Trade Commission against a big toy retailer, Toys R Us. I think Toys R Us just went out of business, but back in the 1990s, they were a very significant player. If you were a toy manufacturer, you wanted your toys to be on the shelves at Toys R Us. And Toys R Us was facing increasing competition from Walmart and some of these other warehouse companies. And so what Toys R Us did was they went to each of the toy manufacturers and they said, we want you to stop selling to our competitors, to the warehouse companies, to Walmart. And the toy manufacturers said, well, we're not really comfortable doing that because we sell quite a bit through Walmart and these others, and we're worried about giving up those sales to our competitors. And Toys R Us said, don't worry about it, we're talking to them, and they're agreeing not to sell to them either. And one by one, each of the manufacturers agreed not to sell to Walmart and Toys R Us's competitors. The FTC found that essentially this was an agreement between the competitors. Even though there was no direct contact between the competitors, Toys R Us orchestrated this agreement. Now, this was just a civil case. The FTC does not have criminal enforcement authority, and so they couldn't bring a criminal case. But I think also the fact that there was no direct contact between the competitors meant there wasn't going to be a criminal case there. A more recent example was brought in the ebooks industry in 2012, I believe it was, against Apple and several book publishers. At this time, Amazon was coming out with its Kindle, and Amazon was introducing lower prices in ebooks. They were selling bestsellers for only $9.99 in US dollars, quite a low price. The publishers were not really happy about that, and Apple at the same time was coming out with its iPad and its plans to introduce ebooks on its iPad. So Apple, much like Toys R Us did, went to the book publishers and said, why don't you change the way you sell ebooks, and instead of selling them to us, Apple, or to them, Amazon, change it to more of an agency relationship where you retain title and you can control what the resale price is. And that way, publishers, we will be able to get the prices of ebooks back up. And again, same kind of pattern where the publisher said, we're not really, we're nervous about doing this unless everyone does it. And Apple said, I'm talking to them, everything's taken care of. The DOJ brought this case, and when I was at DOJ, I did not work on this case. A lot of people asked me, why wasn't that brought as a criminal case? Well, again, I think whether this kind of arrangement is civil or criminal probably depends on two things. One, the strength of the evidence, and if there's very strong evidence in documents that the publishers knew that an arrangement had been made between all of their competitors, then possibly. But I also think if there's no direct contact between the competitors, in that case, the publishers, it's extremely unlikely that the department is going to bring a criminal action. The ebooks case was a civil action, but it was brought. So even though there doesn't seem to be any agreement in this situation, there can be. So be wary of the algorithm company that comes to you making representations about what your competitors are doing. Situation number 4. What about when competitors just independently decide to use the same algorithm? What are the odds of this happening? I suppose if there's a new greatest algorithm out in the market, it's possible. But again, this is the effect. The final effect of this is going to be just like as if all the competitors agreed to do it. But if there is no agreement among the competitors, then there is no violation under Section 1 of the Sherman Act, because again, that requires an agreement. Now, I will give you 2 caveats on this situation. Number 1 is, an agreement does not have to be explicit. It does not have to be written down. You don't have to have direct evidence that, competitor A said, will you agree with me? And competitor B said, okay, I will. You don't have to have that kind of direct evidence. It can be inferred. There's this famous case in the United States involving real estate agents back in the 70s, I think it was, where there was a large group of them in the same room, and one gentleman stood up and said, I don't care what the rest of you do, but I'm going to raise my rates to 7%. And the next guy stood up and said, well, I don't care what the rest of you do, but I'm going to do the same thing. And the third guy stood up and said, I don't care what the rest of you do, I'm going to go up to 7% as well. And that was brought as a criminal case. With that evidence, the department thought, and they were right, that they could convince a jury that what they were really saying is, let's all agree to do this. So it can be inferred, and this looks very suspicious, but if you decide, if your company decides to use the same algorithm and all of your competitors do the same, make sure that there are no communications between you and your competitors about this, and that you can document and prove to the government, whatever agency you're dealing with, that you made this decision on your own. So that's caveat number one. Caveat number two is that even without an agreement, remember, if we're talking about U.S. enforcement here, which is what I'm addressing, the Federal Trade Commission could challenge this arrangement under Section 5, which does not require an agreement. Now, in my opinion, I think it's very unlikely that the Federal Trade Commission would do that unless there was some other facilitating device, like an exchange of information, that made it very likely for all of these competitors to decide on their own to use the same algorithm. Let's say there's a regular trade association meeting, and at that trade association meeting there's some information about what algorithms different companies are using. And there's no discussion about let's all agree to use the same one, but there's some exchange of information which leads everyone to decide on their own to use the same one. In that situation, the Federal Trade Commission might bring a case under Section 5 and enjoin, try to prevent the companies from exchanging that kind of information. So that's situation number 4. The last situation example I want to raise is when competitors' independent use of algorithms, even different ones, can lead to very high prices. This is a situation where competitor A is using this algorithm, competitor B is using this one, competitor C is using this one. It can still lead to an increase in price because, remember, even if the competitors aren't using the same formula, these algorithms do track competitive prices. So what is the legal significance of this? They can lead to interdependent behavior and follow the leader type pricing. The term in U.S. antitrust law for this is conscious parallelism. What conscious parallelism means is, if Harvey is my competitor, we're all picking on Harvey's example, so if Harvey's my competitor, he is setting his prices based on what he observes about what I'm doing, and I know that. And I'm setting my prices based on what Harvey's doing, and he knows that about me. Conscious parallelism. There's a lot of case law in the United States that conscious parallelism is not a violation of U.S. antitrust law because there's no agreement between us. But it can still lead to very high prices if we operate gasoline stations on the opposite side of the street, and I see Harvey come out one morning and raise his price by 10 cents a gallon. I'll go out and raise mine 10 cents a gallon to match it. The next week he may do the same, and I'll do the same. And when I first joined the antitrust division, my sister-in-law, I was explaining to her what the kinds of laws I was enforcing, and she said, well, gas stations fix prices all the time. And what she was talking about was this phenomenon of, probably have it in Taiwan as well, driving down the United States, it is impossible to see gas stations on the same corner with different prices. They're all identical. That does not mean that they're engaged in antitrust violations. It just means they easily observe each other's prices. Well, there aren't many markets like that. Gas stations are one of the few. Most of the prices are harder to observe. They change very fast. Algorithms can make it much more easy for that kind of behavior to happen. But again, without an agreement, it's not illegal. Here's an example of what can happen when just two companies use an algorithm. What can happen to prices? Who is familiar with this, the making of a fly book and what happened to the prices? Okay, so the making of a fly is this obscure book on evolutionary biology, and it was out of print, and the only two publishers that were, the only two companies that were selling it, were each selling it on Amazon. And they both used algorithms to figure out what their price was going to be. Company A and Company B. Company A, I think, wanted to be fairly close to Company B. And Company B wanted to be a bigger gap, higher than Company A, if you see how the math works. And what this led to was just a continual increase in price, because every time B went up, A went up too close, so that when the algorithms that B was using saw that and said, I got to go up again, he's too close to me. And this went on and on and on until the price of this obscure book reached 23.6 million US dollars, which in today's dollars, I figured out, was 692 million Taiwanese dollars. Somebody noticed this on Amazon, someone in a lab that was interested in buying this book. And most of this price change occurred in just a week's time, because again, the algorithms just work very, very fast. And finally, someone brought it, I think, to Amazon's attention or to the publisher's attention, and they finally just pulled the plug on the algorithm and brought it down to a much more reasonable level. I'm sure a very interesting book, but maybe not worth the $23 million. Now, this is a situation where the effect on prices was by far the most dramatic. The other situations, probably when two companies agree with each other to fix prices, they don't say, hey, let's agree to fix our price at $23 million. I don't think the Department of Justice will notice that. They're not going to do something like that. The effect on prices is the most dramatic here, and yet it's great. And that illustrates something important about U.S. antitrust law, and I believe Taiwanese antitrust law as well, and that is the focus is not on the end price, the focus is on the process. So under antitrust law, and it's true in most countries, if the price is set by the market, then that's the competitive price, no matter how high it is or low it is. But if the price is set by agreement between competitors, even if it's reasonable or not as high as you think it might be if competitors were conspiring, that's still illegal, and the Department of Justice puts executives in jail for that. So, some key takeaways. Absolutely use algorithms if they make sense for your company. But don't fall into the making of the fly trap and check the prices that your algorithm is setting every now and then. Don't agree or even communicate with your competitors about price levels, about pricing formulas or about algorithms generally. Which ones are good, which ones are bad, which ones you're using, which ones they're using. And that will go a long way to staying out of trouble. So let's talk about some unanswered questions. What might happen in the short term with algorithms? I think it's very unlikely that there will be any change in U.S. antitrust law to go after the making of the fly type problem. I think the requirement of proving an agreement has been a requirement since the Sherman Act was passed in 1890, and I don't see that changing. The Federal Trade Commission does have a new unit called the Office of Technology Research and Investigation that was recently established, and one of its missions is to look at algorithmic transparency. But that, I believe, is more of a consumer protection concern than a competition concern. Obviously, there's increasing concern about privacy, the amount of data that's collected by companies like Facebook. And I think it's more of a transparency issue and less one about the competitive effects of companies using algorithms. I certainly have not seen anything coming out of this Office of Technology Research that would be relevant to a discussion on competition. What changes might happen in the longer term? I could see the U.S. antitrust agencies being a little more aggressive in blocking deals to try to avoid there being an algorithm monopoly. We talked earlier today about some acquisitions. Google acquired DeepMind, and some of the big technology companies have been acquiring a lot of companies in the AI space. And it's not unusual to see, one algorithm be considered the unique and the best one. There was a case that the Department of Justice brought in 2011 when Google bought ITA Software. And ITA Software was a company that had an algorithm, a tool called QPX. QPX was this algorithm that allowed you to search for the ideal flight. If you wanted to fly from point A to point B at this certain time, we all, make those searches in Expedia or Google Flights. And at least back in 2011, the results that came back were being done by this algorithm called QPX, and ITA had developed it. Google wanted to buy ITA Software, and Google was just about to introduce its Google Flights product. The Department of Justice was concerned that if Google bought ITA, it might deny its competitors like Expedia and Orbitz fair and reasonable access to QPX. And so it allowed the merger to go through, but it required Google for a period of, I think, 7 years to license QPX to its competitors on FRAND terms, fair, reasonable, and non-discriminatory terms. So that was an example where, at least in this one market, the DOJ thought there was essentially a monopolist algorithm. And I could see more of those kinds of actions taking place. It's also possible that you might start seeing the agencies trying to block mergers at lower concentration levels. There are two kinds of competitive effects that come about from a merger. One is called unilateral effects, and that is the concern about this merger is that you're eliminating competition between the two merging companies. That competition is important. That has kept prices low. You're eliminating it, so let's block that merger. That's called a unilateral effect theory. The other kind of effect is called coordinated effects. And what coordinated effects means is the merger is just going to result in one less competitor, and now you're only down to, say, 2 or 3, maybe 4, and that's just not enough. That's going to cause interdependent pricing, and it's just going to cause more oligopoly type pricing and behavior. Well, the whole theory behind coordinated effects is that in some markets you need a certain number of competitors for competitors not to start observing each other's pricing and reacting to that. Well, how does algorithms affect that? The use of algorithms in an industry could lead an agency like the Department of Justice or Federal Trade Commission to say, even 10 competitors may not be enough. If everyone's using an algorithm, maybe 100 competitors is not even enough. That's taking it a little too far, but in terms of merger enforcement, I'm kind of interested to see whether this coordinated effects theory, which is the theory that the US uses in a fair number of mergers, will be affected by the use of algorithms. It's also possible the FTC may increase enforcement under Section 5. And then what about machine learning? Machine learning, what if my Alexa in my kitchen, she just starts saying things on her own without even being spoken to, that's scary to me. And I kind of wonder whether AI is going to result in computers kind of talking to each other and learning how to collude, learning how to avoid detection. What if two algorithms that companies use learn how to collude and fix price? Who goes to jail for that? I don't have the answer to that question, but that I think is hopefully far off into the future. So I don't have too much time left in this session, but I would be happy to take any questions at the break, and I thank you very much. 谢谢。